though the law was passed back in 1997, the beneficial use law was passed in 1997, owners have still sold property since then. And the appellate court was able to say that, no, there wasn't a facial taking because it's proven out in the facts. You still had the sale and purchase of property. But that an as-applied taking occurs when you have the application of a regulation, in this case a beneficial use determination, to property resulting in a deprivation of that use. Here the court said that the claim became ripe for review when the final determination was made in 2002 that you had lost all use of your property, and when the county actually passed a resolution saying that your property had no use to it. The county had tried to argue that, well, the claim isn't right. Even though they've received a beneficial use determination, they could have applied for a variance. And the appellate court said, no, the beneficial use ordinance that you have itself determines that the claim is right, that there are no other uses that can be made on the property. And the trial court erred when it determined that there was a facial taking as opposed to an as-applied taking. The next case, Shands versus City of Marathon, exact same type of beneficial use ordinance. In this case, the City of Marathon adopted Monroe County's ordinance dealing with beneficial use determination back in 1999 when it incorporated. So here the city was arguing the same thing that the county argued in the previous case, saying that when we adopted that ordinance back in 1999, that's when the claims were right. That's when a facial taking occurred. And again, dealt with the same situation where a trial court decided that there was a facial taking and was reversed on appeal. The only difference between these two decisions is highlighted in red here. And the court went on to say in this decision, dealing with the City of Marathon, that there is no taking where an owner can obtain a variance or transferable development rights. So because you have the mere enactment of an ordinance, that doesn't result in a facial taking where residential uses and development rights could be transferred or available, leaving some kind of economic value. So otherwise, the two decisions are identical in their legal pronouncements, as is set forth in the written materials. The next two cases are Burt J. Harris private property rights cases. Ron Weaver, who's going to speak on this topic over the course of our seminar, will talk in more detail about these two cases. The Burt J. Harris Private Property Rights Protection Act is an act that was enacted years ago to allegedly allow an owner to bring a claim to recover compensation for government action that was a little bit less than an inverse taking, what's called an inordinate burden on the property as opposed to a total taking of that property. In this case, in the Caulfield case, the owner had no reasonably foreseeable right to develop their property where the application was filed to close a public. The owner had no right to property even though the city of Jacksonville had closed a public roadway necessary for development. And when an ordinance was passed that closed that roadway, the ordinance did not inordinately have any kind of expectation that the owner could have had to use that property abutting that roadway. And the appellate court here held that the trial court erred when it determined that the city inordinately burdened the owner's property where the ordinance closed an abandoned property that was specifically exempted from the ordinance. To me, this decision is interesting because it does note, in a footnote, the appellate court here notes that it has found no case in which an appellate court has affirmed relief granted pursuant to the Act. So it's kind of a pronouncement on the history of the Burt J. Harris Act and its effectiveness in protecting private property rights when it can find no case in which an appellate court has affirmed relief. The next case is another Burt J. Harris case, Citrus County versus Halls River Development. Again, this is another Burt J. Harris case where we have a difference between a comprehensive plan and zoning maps. In this case, the zoning maps conflicted with the comprehensive plan, and the owners brought a claim saying that they were denied their use of the property because the zoning maps were changed, and that the change of that zoning to make it consistent with the comprehensive plan denied us the more intense use of our property. The appellate court said, well, general land use law, that the comprehensive plan is kind of the constitution of land use, have no right to rely on zoning when it's inconsistent with the comprehensive plan, and that's what happened here. The owner tried to rely on the zoning that was inconsistent with the comprehensive plan, and the owner should have known that the designation in the comprehensive plan controlled over the land development code and the zoning maps, and you could not equitably stop in this case, the county from having the wrong zoning inconsistent with the comprehensive plan, and that the trial court erred in this case in determining that the county had inordinately burdened the owner's property, and the owner had a vested right to develop. We'll have a couple more cases to wrap up here. Pinnacle 4 covering. This case is censored materials were submitted, has been cited in Florida Law Weekly. If you want to add in the citation there of 1610, that'll complete your materials for you. In this case, it's a unique decision coming out of the second DCA. You have a case where DOT sought to take some property. After DOT sought to take that property, the property burned down. The business burned down prior to the taking. The owner ended up settling the compensation for the taking of the real estate, but still had a business damage claim that was outstanding. And they argued to a jury that, okay, our property burned down, but we would have rebuilt it if there had been no taking, so we should be paid our business damages. The jury didn't agree and awarded zero compensation for business damages. And after that trial, the business owner sought to recover experts' fees and costs for litigating business damages where they had recovered zero. And the appellate court said, well, we got to look at the statute. The statute only authorizes an award of experts' fees and costs for business damages in an eminent domain proceeding where business damages are compensable. And if you recover zero, well, the jury has decided business damages are not compensable. So here, the jury expressly found that the threat of condemnation did not damage or destroy the business. The fire did, and the business was not entitled to business damages. So business damages themselves were not compensable, and the experts and attorneys' fees for business damages were not compensable as well. So the trial court was affirmed in that decision. The only non-eminent domain case I want to talk about is Amorous Life Insurance versus Late. This is a Florida Supreme Court decision. For those of us who are lawyers, there is a rule in Florida that requires that a motion to tax attorney's fees and costs to be filed within 30 days of the entry of a final judgment. That's Rule 1.525. And there's been a lot of litigation over what that rule means, because lawyers cannot file motions to tax attorney's fees on time for some reason, even though the statute requires they be filed at the most 30 days from the entry of a final judgment. In this case, you had a party who did not file their motion for attorney's fees until about 8 months after the initial final judgment was entered. There were some successive amendments to those final judgments where the party was trying to claim that the period was told, but there was no timely motion filed. What's different about this case is the final judgment that was entered already said you're entitled to attorney's fees and costs. So the entitlement was not an issue in the final judgment, and that's different from a lot of cases which just reserve jurisdiction to determine entitlement and amount. And in this case, the Supreme Court of Florida said, where you've already got entitlement determined, you're already on notice that that you're going to be having to pay attorney's fees and costs. So the 30-day time period does not apply where entitlement has already been decided. And that's opposed to where you have entitlement and the amount both to be decided. When you have entitlement and the amount to be decided, then you've got time to file your motion. But where you just have the amount to be decided and entitlement has already been decided, you don't have to worry about filing a motion on time. So the court narrowed the application of the rule of civil procedure